Earlier this year, Channel 5 had to pay out 2 large settlements to people who had appeared in their programmes. Some of you will know the TV series Can't Pay, We'll Take It Away. For those who don't, it's a tacky programme in which cameras follow around a team of certificated bailiffs or sheriffs as they carry out their work enforcing civil judgments. I think the people in the programme are sheriffs, which in England and Wales is an informal term for High Court enforcement officers and agents. What typically happens is that the TV crew will enter the private property along with the High Court enforcement agents, and permission for filming will be sought from anyone present. As you'd expect, permission is very often refused, and when that happens, any footage captured is never broadcast and has to be destroyed. In the 2 cases that ended in Channel 5 having to pay out money, the individuals refused permission to film, so the camera crew stopped filming, but footage from the body cameras used by the High Court enforcement agents was handed to Channel 5 and broadcast anyway. It's not clear whether this was by accident or on purpose, but as a result, footage of these people when they were having their homes repossessed or subject to collection of debt was broadcast without their consent to millions of people. Not surprisingly, they sued Channel 5, and not surprisingly, Channel 5 recognised they were in the wrong and agreed to substantial payouts to each claimant, and Channel 5 also had to give undertakings in court never to broadcast the footage again. The solicitors for the claimants explained that the programme wrongly revealed matters that were private to the claimants, which took place in their own home. The filming of them within their home and subsequent broadcast of the private information obtained in that way to over 10 million people amounted to a grave misuse of their private information. In open court, the claimants accepted an offer of settlement in relation to their claim and received a substantial damages payment in recognition of the nature of the intrusion suffered and serious breach of their Article 8 rights. They are both very private individuals and live in a small community, and word soon spread about the programme amongst people they know through work and socially, so you can imagine the damage that did to them. Article 8 of the Schedule to the Human Rights Act, which I've just mentioned, protects your right to respect for your private life, your family life, your home and your correspondence. You may be wondering why I'm mentioning all this and what it has to do with auditors. Well, let's consider the following points. First, bailiffs and sheriffs are acting on an order of the court and, in the case of domestic property, cannot enter without having obtained permission of the occupier on that or previous occasion. Second, bailiffs and sheriffs may film what they do, but that is for the purpose of their own security and for the protection of the individual they're visiting. At all times, what they do is subject to rules and controls in every aspect of their work, and they work under the supervision of the court, and there are various formal safeguards in place. Companies have the same protection under the Human Rights Act as natural persons, subject to certain obvious restrictions on the interpretation of that, bearing in mind that companies can't have the same rights in practice as natural persons, but that's decided on a case-by-case basis. The point is that any business or group or organisation can benefit from the right to respect for its private life, either as a company or as a sole trader or as a collection of individuals who may be partners or trustees or whatever. The case of Amann and Switzerland in the European Court of Human Rights, which was heard in the European Court on Human Rights in regard to Article 8, said that for the purpose of Article 8, private information can be defined quite broadly and can include business information. The European judges said information about the way that a business is operated should be treated as private information for Article 8 purposes. The case of Société, Campbell and France also upheld this principle. The case was brought before the European Court of Human Rights regarding the violation of a right to respect for private and family life from Article 8 of the Convention. The court established that the concept of home could be applied to all business premises of companies. Now, although a dispute between a company and an auditor is a private dispute in which the Human Rights Act has no direct effect, The court is an organ of the state and therefore must have regard to the rights codified in the Human Rights Act. This has been achieved by the English courts by creating what is known as the tort of misusing private information. The origins of this civil wrong go back to a 2004 case in the House of Lords, Campbell and MGN Limited. Misuse of private information claims are concerned with the protection of human autonomy and dignity, the right to control the dissemination of information about one's private life, and the right to esteem and respect of other people. This leads to this question that I want to ask. When auditors visit business premises, could the tort of misusing private information apply? Here's some further points to consider that may help us answer that question. First, most businesses have a reasonable expectation of privacy to some degree or other in their business affairs. Business owners and company directors will have additional expectations of privacy in respect of particularly sensitive aspects of the business. Next, businesses that have premises open to the public will expect that those with permission will enter. Permission can be given or it can be implied. Implied permission would be for suppliers, customers and others with a purpose that falls within the reasonable expectation of the business. This could include members of the public who are just curious about the business and want to take photographs and ask questions. There's nothing wrong with that in principle. But those people will come onto the premises with the purpose of seeking consent and will understand that if they are asked to leave, they must leave. Journalists could be more assertive perhaps in pursuit of facts or information not readily available elsewhere, but ultimately journalists are not exempt from trespass law or the general law and still have to justify their actions as reasonable and in pursuit of the public interest. This includes having to justify any exemption they wish to claim from the data protection regime. Auditors are not acting with the consent of the occupier or under any lawful authority. They never ask for permission to film and always refuse to stop filming when asked. They even sometimes refuse to leave the premises when asked. They never give their names or disclose the name of their YouTube channel or even which social media platform they are publishing to. They deny any opportunity for the people they film to consent to having the recording published online. In the process, auditors often without consent capture information about the business that the owners or directors might reasonably have expected to keep private, including personal data as defined in the Data Protection Act 2018, such as digital captures of faces. Although claimants have increasingly sought to bring misuse of private information actions alongside data protection claims for personal data breaches, it is important, admittedly, to remember that individuals do not have a reasonable expectation of privacy with respect to information purely because it happens to be personal data. Article 8, which is just to remind you, is the protection of privacy, will only be engaged if the interference in question is not trivial. And the Court of Appeal has noted that people are expected to adopt a reasonably robust and realistic approach to living in the 21st century. In that regard, the High Court has suggested that public figures, for instance, are expected to have thicker skin than private individuals. But the people captured by auditors in these videos are private individuals, not public figures. And publishing images has been found to be particularly intrusive, and it has resulted in a number of successful privacy claims, such as in the David Murray case, which I linked to in the description, and in cases involving Princess Caroline of Monaco and Paul Weller's children. Again, I linked to those cases in the description. Auditors publish this intrusive information without a careful consideration of whether there is any overriding public interest in doing so. That they do not do so with any transparency, consent or accountability suggests a misuse of private information in that there is no public interest. The auditor is acting purely for his own ends. Now, what I think all this points to is a possibility, I only say a possibility, of a class action against YouTube and auditors for misuse of private information, as well as possibly trespass to land and breaches of data protection in regard to the auditors. Now, it's important to state here that Article 8.2 of the Human Rights Act specifically envisages that there will be some circumstances when it is necessary to interfere with a person's rights of privacy. It sets out the conditions that must apply before such an intrusion is lawful. To be lawful, an intrusion into a person's private life must be in accordance with law, necessary in a democratic society, and in pursuit of a legitimate aim. If an auditor is trespassing, then he is not acting in accordance with law, but he may be able to defend and justify the trespass under Article 8.2 or Article 10 or both. But are the activities of these auditors necessary in a democratic society or in pursuit of a legitimate aim? I would argue not, due to the way the auditors behave. Their real aim is to engineer drama and confrontation and bully, abuse and humiliate business owners. While what the High Court enforcement agents do in the Channel 5 programme is more legitimate, there is a similarity between auditors and the High Court enforcement agents on Can't Pay, We'll Take It Away. Both of them have set out to ride roughshod over the dignity of ordinary people and humiliate them. Auditors claim to stand up for people's rights, but in reality they trample on people. Imagine just for a moment that you're at work or you own a business and all you want is a quiet life and to provide for your family. You don't ask for these people to turn up. You ask them to stop filming when they do, and they ignore you and even refuse to leave the premises. And they refuse to tell you where the video will be published or even give you an opportunity to object. You then find yourself broadcast on a major social media platform. That is an infringement of people's rights. The court will take into account, in considering all this, the words of Lord Neuberger in the 2011 Court of Appeal judgment in Ambrosiadou and Coward. What Lord Neuberger said is this: just because information relates to a person's family and private life, it will not automatically be protected by the courts. For instance, the information may be of slight significance, generally expressed, or anodyne in nature. While respect for family and private life is of fundamental importance, it seems to me that the court should, in the absence of special facts, generally expect people to adopt a reasonably robust and realistic approach to living in the 21st century. Yet, as long as some loss or distress has been suffered, remedies are available, even taking into account the words of Lord Neuberger just there. The possible remedies available for misuse of private information, if such is established, would be an injunction, which in this case would be an order of the court that the auditor removes the videos from any social media platforms and undertakes never to publish them again in any form or visit the premises again or approach the premises again or any of its owners or staff without having a reason. There could also be compensatory damages or account of profits based on the auditor's earnings from the video, provided it can be shown that loss or distress was suffered. Section 169 of the Data Protection Act 2018 and Article 82 of the UK GDPR also allow the victim to claim damages for data breaches where this has taken place. But none of what I've said, and this is very important, none of what I've said precludes the possibility that auditing done respectfully and in accordance with the law could be a legitimate activity and could even be seen as necessary in a democratic society, taking into account the jurisprudence of the European Court of Human Rights in regard to Article 8.2, which I outlined earlier. It's all down to how you go about things. I think the way auditors currently go about things could put them in legal jeopardy, and there is at the very least the possibility of class action litigation against both auditors and YouTube.